state law under 6A, and basically what they've done is redefine what is affected in terms of the weaponry that's affected currently. The word used is firearm, and this change in the law basically expands upon that so that it includes deadly weapon, firearm, and pepper spray. So it broadens the terms that are limited under this period, this section on municipalities. That's what where the code section is on municipalities. And the deadly weapon is referred to back to Chapter 61, 7.2, which would include a blackjack, a gravity knife, a switchblade knife, a nunchucks, metallic or false knuckles, pistol or revolver. So the first part of the bill simply just limits the range of weaponry that the municipality cannot regulate or restrict more strictly than state law. The second part of this bill is what we talked about yesterday. Basically, in the past, and let me just give a little bit of history to add some context. Prior to 2014, municipalities had the ability to enact ordinances to control deadly weapons within their community and enforce those ordinances by arrest. In 2014, Senate Bill 317 was introduced. It basically had provisions in the bill that totally preempted municipalities from any type of regulation of dangerous or deadly weapons within their jurisdiction. As that bill was introduced, the language was as follows: except as otherwise provided in this section or is expressly authorized by a statute of this state, the legislature hereby occupies and preempts the entire field of regulation in this state touching in any way upon firearms, ammunition, and firearms accessory to the complete exclusion of any order, ordinance, or rule promulgated or enforced by any political subdivision of this state. That was the bill as it was introduced. As you might expect, it ran into a lot of opposition, especially those for whom the term local control was more than just a hollow campaign slogan. And so there was a good bit of debate in the Senate. That bill was introduced on January the 10th. Ultimately, as a result of substantial long-term negotiations, on the 15th of February, there was a strike and insert introduced. This bill was like 27 pages long, the strike and insert by Senator Palumbo, which basically inserted the compromise language that is now in the code, which basically reserved unto the municipality some control of their own municipal, within the municipality's boundaries. Basically, that bill, that strike and insert bill, or that strike and insert amendment, passed the Senate 32-0. So it represented a compromise between those who favored local control and those who wished to preempt local control in that particular issue. The bill came over to the House and passed by a vote of 92-5 in the form that it left the Senate. The 5 nays are no longer members of the legislature, and coincidentally, you might, if you looked at that roll call, you might reassess your opinion of whether or not we need term limits, because about half of those people are no longer here. In any event, I digress. In any event, as you recall yesterday, the bill that came out yesterday was a result of amendment in the Political Subdivisions Committee that reinserted that provision of the code that was in the bill as it came out of the Senate in 2014. And that provision basically was a very modest, limited exception to this preemption doctrine that basically said that the municipalities were not permitted to restrict the carrying or possessing of firearms which are otherwise lawfully possessed on a public street or sidewalk of the municipality. So that was the general prohibition. The provision the provided language was that whenever pedestrian or vehicular traffic is prohibited in an area of a municipality for the purpose of a temporary event of limited duration, not to exceed 14 days, which is authorized by a municipality may prohibit persons who do not have a valid concealed handgun license from possessing a firearm in the area where the event is held. That was the language that was in the bill from 2014 until yesterday. Actually, it was stricken in the Senate and reinserted by agreement of various stakeholders in the Committee on Political Subdivisions, and then included in the bill that came, or included in the strike and insert that came to the judiciary. Unfortunately, in opposition or in direct violation of that agreement, an amendment was offered yesterday on the floor to take that language out. So here's where we are. The bill before you is the result of what I consider deceitful bait and switch tactics, which certainly offend me. It may not offend you, but ordinarily at this point in the presentation and the explanation of a bill, the person making the explanation urges passage of the bill. I cannot in good conscience encourage this kind of tactics. I won't be here next year, but I won't do anything in my final days to cause this type of tactics to be reinforced in any way. So therefore, I do not encourage passage of this bill. I will be voting red, and I encourage you to follow your own conscience.
The question before the House is, shall the bill pass? Are there members who wish to speak to passage of the bill? The gentleman from the 25th, Douglas Painter, is recognized.
Thank you, Mr. Speaker. You know I'm rising in support of this. This bill falls under the two most basic God-given rights for me: the right to life and the right to defend that life, as well as the lives of those around you. Local control means absolutely nothing to me when my life is on the line. That is strictly my right. That's not a control issue. Thank you.
The lady from the 50th, Douglas Longstreth.
Thank you, Mr. Speaker. May I ask a question of the Judiciary Chair?
Does the chairman yield for a question?
As always, yes.
Thank you, Mr. Chair. The other day we had the amendment, and the amendment was to be that the municipalities could keep firearms off of municipality property. Is that correct? I mean, if they have affairs and festivals.
To the gentlelady, the bill that came from the Senate struck that language. The bill, the strike and insert amendment that came onto the floor yesterday, it reinserted that language. So yes, in the limited circumstance, a municipality could prohibit anyone without a concealed carry permit from carrying a firearm in those limited fairs and festivals type situations up to a period of 14 days. It was an option and not a requirement. It's permissive.
It was permissive. And now is that put back in the bill? So now when you're saying the bill, you're not for this bill, it's because the municipalities can do that or cannot do that?
To the gentlelady, I'm not in favor of the bill for two reasons. One was the tactics that were used to get to the point we are today, which I don't think ought to be encouraged in this body. And number two, I am a person who believes local control, and I think in those limited circumstances where you have crowds, it's a reasonable protection of the crowd that the municipality has the option to say we want only people that have training and have passed a background check to carry weapons during that period of time. Otherwise, you could have someone who may not be trained, who doesn't know enough to engage a safety on their firearm. You're bumped and bustled around in a crowd, that weapon could fall out. I mean, there's any number of things that can happen. So, yes, I'm opposed to the bill for those two reasons.
And to make it clear, maybe for people who are listening also, this bill does allow that to happen.
The bill
as it is written.
The bill will not allow a municipality to prohibit anyone from carrying a deadly weapon.
That's what I meant. Okay.
During those fairs and festivals.
Thank you.
Or at any other time.
Thank you.
Mm-hmm.
The gentleman from the 40th, Douglas Jeffries.
Thank you, Mr. Speaker. And I'd like to thank the members of this House that in a large number voted against the amendment the other day that would have killed constitutional and God-given rights to defend yourself. I applaud you for that. As far as a bait and switch goes, I'm the one that introduced an amendment. I am not in judiciary. I'm not in the other committees where this bill traveled through. So as far as something of a bait and switch, I was not a part of that, don't know anything about it. I introduced this bill last year where it died in a committee because it was an unfriendly gun bill that somebody didn't like. I saw the opportunity this year when this bill came from the Senate. I believe it was 30-2 in favor of the way it is now. After the amendment, I saw the opportunity to insert the language as an amendment with a bill I tried to introduce last year. There was no bait and switch there. That was me seeing a way to protect God-given rights and constitutional rights. So I don't understand the bait and switch thing that's being thrown out there. I think there's a lot of misconceptions about permit carry and what a permit does. A permit is a card that you paid a few $100s for the process, and the concept only takes 30 minutes to do. That's far from true. It's about 45 days plus the day of training and the expense of training. But it does not protect us from evil intent. Just because you have a permit does not take evil intent out of your heart. And just because we say you can't carry a gun in a fair festival situation does not keep you from renting a hotel room and firing shots down into this fair festival. You're mistaken by that. It's the intent of somebody's evil in their heart that does that, not a permit. This permit that we have in West Virginia, other than paying for it to say you have a permit, maybe you'll speed up when you go to purchase a gun. The only other thing it does is allow you to carry across state lines. Other than that, in West Virginia, we have constitutional carry. We decided, after having a permit, that we have the constitutional right and God-given right to defend and protect ourselves. All that amendment did the other day was clean up language and extend it to everybody. It quit the discrimination of those that can't afford the process of going through a permit, can't afford the process of going through an NRA training class and spending the time of doing that. Much more than 30 minutes, may I add. So this is cleanup, it's fairness, and it's protection of the Constitution and God-given rights. Thank you. I urge passage.
The gentleman 27th, Dr. Porterfield.
Thank you, Mr. Speaker. I rise in support of this bill. I am certainly for local control when it comes to taxes, education, and other issues that are non-constitutional or foundational in their inception. But municipal government, county government, nor state government has any place or any right to deny us our constitutional liberties, including the Second Amendment. The amendment that was put in place, I believe it was on Saturday, I don't think yesterday, unless you all were here and I missed church, and I was here at church and I missed being here, but I'm thinking the gentleman was referring to Saturday on the amendment that we had for clarification. But that amendment would have been a hindrance and a setback and would have given permissive authority to a municipality to limit a foundational right for us as law-abiding citizens. I am glad that that amendment was defeated under whatever circumstances that it was placed there, and I certainly do not believe that any municipal government, any county government, or any state government, or anyone else should deny us our foundational constitutional rights to bear arms for those of us that are law-abiding citizens. I urge passage of the bill. Thank you, Mr. Speaker.
Are there other members who wish to speak to passage of the bill? If not, then the question before the House is, shall the bill pass? Those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, there are 81 ayes, 17 nays, and 2 members absent not voting. Majority having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for Senate Bill 96.
Are there amendments to the title? If not, title is read by the clerk. Will be in the main title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for Senate Bill 201 relating generally to criminal offenses of stalking and harassment.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection and recognizes the gentleman from the 27th Delegate Schott to explain the bill.
Thank you, Mr. Speaker. The bill removes stalking as a separate offense and replacing it